The fact that the Trayvon Martin case is embedded in a larger denial of our conversation of the role race plays, from pretextual stops to stop and frisk to the death penalty, it is that which makes it a symbol of a greater frustration. The thing that we all notice, the thing that gripped the hearts of the country, and the reason people are protesting is because there's a conversation that everybody knows is at the center of this case that was left out of court. And one of the problems we have is our inability, I don't mean just in this case, but our systematic inability to address this in a court of law.
You say that race and law can't be cleanly separated. What do you mean, and specifically, how does that apply to this case?
It's impossible to separate race from this. And indeed, one of the things that's most frustrating to many people, black and white Americans, is the awkward dance that was had with race in this trial. From a judge who surely was trying her best and surely trying to be expeditious, but her first ruling on race was that the prosecution could notice that George Zimmerman profiled Trayvon Martin, but could not use the phrase racial profiling. This is a bizarre compromise, as though we understand what that might mean outside of racial profiling. And that compromise came to stand for the role of race in the entirety of the trial. If the prosecution's case was that George Zimmerman was guilty of second-degree murder, that he got out of his car with malice aforethought, as we say in criminal law, in their words, with hate in his heart, it's impossible to understand why that would be true unless George Zimmerman recognized and thought of Trayvon Martin as, to use his words, one of those punks who always gets away with it. And that's impossible to explain without an explanation of George Zimmerman, in fact, thinking of Trayvon Martin as a young black man who was the type who was up to no good, to use his words, and a criminal to be stopped.
What are you hearing from your students today as you talk to them about this case?
Our students have turned to not just myself, but other faculty members to discuss this case. And you can feel with them not just disappointment, but the same frustration, anger, and confusion we all have. What they're really wondering is what role they ought to play when they become lawyers in dealing with these. If these kind of things happen, no matter the lawyering, they feel as though perhaps it's powerless. We oughtn't forget how far we've come. I teach the Scottsboro boys cases, and in those cases, the mere accusation of rape, almost entirely fabricated, was enough to send a group of young black men barreling towards their death. And it was only federal intervention that saved their lives. Thanks to decades of lawyering, those cases are at least we can say less likely to happen. And so it reminds us that it is a long and noble project. And it is not for us to collapse in the face of frustration today, but rather it's to remember our rules and the long-term project of bringing better and better justice that makes us lawyers. And so we're reminding our students that now is not, despite the sadness or frustration one feels on any side of this case, now is not a bad time to be a lawyer. Now is a great time to be a lawyer.
Okay, so what are the lessons of the Trayvon Martin case?
I think the lessons of the Trayvon Martin case are difficult, and there are many. But among the most important lessons is that we do ourselves no favors when we refuse to have the most honest conversation about the way in which race affects the entirety of the trial. And that's true from the ways in which Trayvon Martin was approached, identified, followed, and whether or not George Zimmerman read him as a reasonable threat before or after, and frankly, whether or not the jurors understood George Zimmerman to be the person who was the legal, not just provocateur, but instigator. It seems to me that had George Zimmerman been an older black man following a young white child, one might have well thought that he was a legal instigator in a way that would rob him of the ability to claim self-defense. When law and race are so deeply intertwined, the constant refrain that we will have that conversation another day is to do a disservice to everybody involved. And one of the things we as a lawyer have to do is to have the same conversation that everybody else in the country is having within our law.